Okay, our next item is subdivision 2021-06, Coral Lakes, formerly known as Coral Crossing.
So, Mr. Chairman, this item is on the agenda basically to advise the Commission where this stands procedurally at this stage. As you'll recall, that was a subdivision that was considered by the Planning and Zoning Commission, denied, and then the denial was appealed to County Council. County Council had its hearing, and then County Council issued a motion remanding it back to the Commission for consideration, not another hearing, but consideration of the information and then another vote on the matter. What I'm going to do, just so everybody has it, is just a paper copy of the motion that was read at County Council, so if you want to take one and pass it down. I'll just summarize it really briefly, and you can read that at your leisure. The plan is just to explain what happened, and we'll put it back on the next meeting for the actual revote. The council actually, they found in our favor with regard to the 45-day time limit for acting on a subdivision, basically finding that the 45-day clock that's in Title IX begins to run at the time the record's closed on a matter following the public hearing. And then the next one is the Commission engaged. They found the Commission engaged in an orderly process, but there was no evidence of a logical review of the record. Now, one of the things they state in here is the appellant alleges that the Commission's conclusion was not the result of an orderly and logical review, or excuse me, appellant alleges that the Commission's conclusion was not the result of an orderly and logical review of the evidence and the provisions of the subdivision ordinance, and the council motion, and it was a 3-2 vote, agreed with that in part. The council said that while the Commission reviewed the submitted documentation and discussed a variety of issues pertaining to the site, including but not limited to wetlands, drainage on the adjacent site, interconnectivity, stormwater design, Bell-Dot issues, adjacent developments, an archaeological study, the adjacent airplane landing strip, and more, council found that they were unable to determine how the evidence was analyzed because the Commission failed to provide any reasons in support of the vote. Therefore, they found that while the process itself was orderly, it was not clear that the review was logical. And then the third thing, because there was 3 issues on appeal, was the Commission's vote that the Commission erred, or the Council's vote that the Commission erred when it failed to provide adequate reasons for the denial of the application. And basically said that there was a motion made, and then it just failed because it didn't get the 3 affirmative votes, but there wasn't any reason given why the subdivision should be denied. So for that, that's an overview of what council did. So now, I wanted to explain that to you. I don't expect there to be a motion because you needed to know what you're supposed to do first. And so I wanted to give you that overview of council's decision. So we'll put it back on for the final meeting in June.
So, Mr. Robertson, do you who voted to send it back to us?
Council did.
You say it was 3-2?
Yeah.
Who were the 3?
It was Mr. Vincent, Mr. Riley, and Mr. Hudson. I mean, although that doesn't really matter because it's majority of council that votes, to make any decision.
And why did they not just choose to have their own hearing over the issue?
Because they can't. They're not permitted to do that. Chapter 99 states that their review is on the record of the Sussex County Planning and Zoning Commission hearing. So they cannot do their own hearing. They're not. It would be a due process violation if they had a do-over.
So basically, when we voted, when it was a 4-1 against it here at Planning and Zoning, we should have each individually stated why, or that we were not in agreement with the motion.
I will say 2 things, because I was asked to state on the record the law about subdivisions, and I stand by that, and I will restate it again next week or next meeting, because it's correct. Subdivisions, and if you want, I'll read it again tonight, but subdivisions are governed by code, and if you meet the standards for a subdivision, state law has determined, as well as the legal decisions that have reviewed it, that if you meet the standards of a subdivision, it has to be approved, although you can put conditions on it. I stated it then, and I'll state it again. So, the Commission is hard-pressed to deny a subdivision. I don't like having to say that on the record, but that's what the law is, and we've got to live with it. And so, really it's County Council that has the ability to change the subdivision and zoning codes that are applied against a subdivision. So if you want to change the standards for approving or denying a subdivision, county council's got to change the code which sets up the rules for doing that. But you're right, the vote would have to be, there would have to be a motion to approve it, again, seconded, and 3 votes stated, at least, in favor of that motion with reasons given why that motion should be approved. Or if it's going to be denied, there has to be a solid motion made to deny the application, seconded with at least 3 people given reasons why they feel it doesn't comply with the subdivision code and should be denied.
So then my question, Mr. Vincent, is...
Mr. Robertson. Mr. Vincent, he's...
He's one of the ones that voted to bring it back to us.
Yeah, right.
Yeah. So my question is, when all these folks come before planning and zoning, when we have these public hearings, and they give us all these reasons that are outside of those for which the developer is burdened with meeting, should we not provide that same explanation before each public hearing, that planning and zoning doesn't make the rules? Planning and zoning simply has to follow the rules, and if the rules need to be changed, that's done at county council level. Is that what you're saying?
Well, that's a call whether you all want to make that statement. I mean, that is the law, though. I don't disagree with that. It's whether, like, for example, when I give the rules for how we conduct public hearings, if you wanted to add a statement like that to those rules, maybe that makes some sense. Because I will tell you, sort of informally, like whenever I get an opportunity, and to explain that to folks in the public, I try to educate people. Not, when we're sitting up here so much, but, when people ask about it. Because I think, as I said, I think the last time, reasonably, I think people misunderstand that. They think that there's more discretion on a subdivision. Now, remember, that's different from a change in zone, RPC, or conditional use, or some other things. But on a subdivision, I don't think people appreciate, what you're tasked with doing based on the code, so. I don't have any problem with that. I think we could probably boil it down so it's not a big, long explanation, but, make that explanation.
I agree with Commissioner Hopkins. The public doesn't understand the duty we're tasked with following the law.
Right.
And they think that we'd love to involve their opinion in our decision, but a lot of times we can't.
Yeah. And I will say, that's I have to think about it because there's some nuance to that, too. Like this particular subdivision predated, it's in the coastal area, and that used to be a different set of standards. The coastal area didn't have to prove superiority. We've since changed that, so it's superiority everywhere. This one predated it. But to some extent, if it's now a cluster subdivision anywhere that's been filed, there's still a superior design standards. But we could incorporate that into that explanation as well, just so people kind of know what the rules of the game are. Yeah.
I think that's a great suggestion.
I'm good with that.
No, I can definitely work on that. Yeah. That way, it's just said all the time, and or somebody's not saying it every time we have a hearing. It's just part of the spiel. Yeah.
Okay, anything else? Not, but since that requires no action, we'll move on to the next item on the agenda, which is